Hello students, this is exercise number 21 of the Progressive Monthly Magazine, December 2021 on the speed of 100 words per minute. Start. The challenge laid is to an order passed by the High Court of Punjab and Haryana, whereby anticipatory bail has been granted to respondent number 2, who is the mother in law of the deceased and is charged under sections 304B, 302, read with 120B of Indian Penal Code. The prosecution version in brief is that the appellant, who is the father of the deceased, lodged an FIR against seven accused persons, four of whom are members of the in law's family of the deceased, including the respondent accused. The complainant has alleged that his daughter was married to the son of respondent accused on 28/7/2017. Soon thereafter, the accused family members started to harass and physically torture the deceased on the pretext of dowry demands. His daughter died an unnatural death in suspicious circumstances. There are specific allegations vis respondent accused alleging that she exploited the deceased and deprived her of any chance to recuperate from the hard domestic chores. This was despite the fact that deceased was also working as a full-time lecturer in the local government college. It was further alleged that due to non fulfillment of the dowry demands, the vicious cycle of humiliation and abuse continued to be meted out to the deceased. The deceased contacted the complainant on 30/9 2017 and informed that she had been again physically tortured because of her failure to meet their dowry demands. The complainant assured that he would try to amicably settle this household squabble by coming to her marital home on the very next day. However, this assurance could never be materialized as the accused are alleged to have clandestinely administered poison to the deceased on 1/10/2017, which led to her unfortunate demise the following morning. It is to be noted that the fact of poisoning is supported by medical evidence gathered by the investigating agency. Soon after the FIR was lodged, the respondent accused moved an anticipatory bail application before the Sessions Court, which was rejected on 21/12/2017. Discontented, the respondent accused approached the High Court for a similar relief, but the petition was dismissed as withdrawn. Meanwhile, on account of non cooperation with the ongoing investigation, the SHO of the concerned police station applied for and got issued arrest warrants against the respondent accused from judicial magistrate. However, the arrest warrant could not be executed. The respondent accused continued to evade her arrest until this court granted anticipatory bail to her younger son on 22/10/2019. Thereafter, taking advantage of this subsequent event and presenting the same as a material change in the circumstances, respondent accused filed two petitions before the High Court seeking quashing of the order that declared her a proclaimed offender and further sought the relief of anticipatory bail. It is noted explicitly that during the pendency of the above mentioned proceedings, the High Court granted interim bail to the respondent accused, and pursuant thereto, she joined the investigation. Thereafter, while the impugned order, High Court allowed both the petitions and set aside the order declaring the respondent accused as an absconder, and also granted her anticipatory bail. These reliefs were primarily allowed on two grounds. Firstly, that the respondent accused had joined the investigation and undertook to remain present at each date of trial proceedings. Secondly, she was entitled to seek parity with the co accused, whom this court granted anticipatory bail. The aggrieved complainant is before us, contending inter alia that the High Court has committed a grave error of law in overlooking the well established principles which guide courts to exercise their discretion in the matter of granting anticipatory bail. Learned State Counsel has also supported the cause of appellant complainant. We have heard learned counsel for the parties at length and perused the relevant material placed on record. At the outset, it would be fruitful to recapitulate the well settled legal principle that the cancellation of bail is to be dealt on a different footing in comparison to a proceeding for grant of bail. It is necessary that cogent and overwhelming reasons are present for the cancellation of bail. Conventionally, there can be supervening circumstances which may develop post the grant of bail and are non conducive to fair trial, making it necessary to cancel the bail. This court in Daulat Ram and other versus State of Haryana observed that rejection of bail in a non-bailable case at the initial stage and the cancellation of bail so granted have to be considered and dealt with on different bases. Very cogent and overwhelming circumstances are necessary for an order directing the cancellation of the bail already granted. Generally speaking, the grounds for cancellation of bail broadly are interference or attempt to interfere with the due course of administration of justice, or evasion or attempt to evade the due course of justice, or abuse of the concession granted to the accused in any manner. The satisfaction of the court on the basis of material placed the accused another reason justifying the cancellation of bail.